Good afternoon, everyone. Welcome to the Joint Select Committee established to consider the Cybercrime Bill 2017. We are live from the Parliament. We are also broadcasting on our radio frequency 105.5 FM and, of course, on ParlView, which can be found on the YouTube channel feed. I'm the chairman of this committee, Faris Al-Rawi, and I would be very pleased to ask the members of our committee to introduce themselves before we go over to our first stakeholder submission this afternoon, which is, of course, from the AmCham itself. May we start perhaps with Member Gopi Schoon?
Good afternoon, Paula Gopi Schoon, member.
Good afternoon, Barry Padrat, member.
Good afternoon, Ronald Huggins, member.
And good afternoon, Edmund Dillon, member.
Good afternoon, Shamfa Kudjo, member.
A pleasant good afternoon, Melissa Ramki-Soon, member.
Good afternoon, Clarence Rambarat, member.
Thank you very much. And may we invite our esteemed guests, please, to introduce themselves to the listenership of Trinidad and Tobago.
Good afternoon, everybody. Nirad Tiwari, CEO of the AmCham Trinidad and Tobago.
Good afternoon, everyone. Aurelia Bruce, Research Officer with the American Chamber of Commerce of Trinidad and Tobago.
Thank you very much, and very pleased to have you. I offer apologies for some of our members, some of whom are en route, others of whom have conflicting engagements with other Joint Select Committee meetings happening literally at the same time. We're very pleased to have this afternoon the AmCham join us. Specifically, we wish to thank you for your written submissions, which the committee has received, and which goes into some proper detail as to matters of concern and also general comments. The committee is very pleased to ask you to commence your discussion with an opening statement, and then if we'd ask you to dive straight into the material that you wish us to consider, bearing in mind, of course, that the population doesn't have the benefit of your written submission, but at the same time asking you to be as concise as possible so that we can engage in the fulsome discussion which we have in mind this afternoon. So over to you, Mr. Tiwari.
Thank you, Mr. Chairman. I'll be very brief with the opening, which is simply to say that we, as a chamber representing the interests of business, with a view to making the environment in our country more conducive to development for all. We view the passage of the Cybercrime Bill as an imperative. However, we wish to highlight a few points. The two main ones are that whatever the fines and penalties which are prescribed in the bill, that they be sufficient to deter cybercrimes and not minimal so as to be passed off as a cost that could be borne in the commission of a crime that may have some commercial benefit to the perpetrators. The second is that while this bill is absolutely necessary because of its reach and the ubiquity of electronic communication and the utilization of hardware and software, we are very mindful of the need to balance privacy rights and also to ensure that the public interest is never undermined through the passage of legislation such as this.
Thank you. May we invite you into the meat of your submission. Of course, members have had the benefit of properly consuming your submissions. May I ask, just out of interest, whether these submissions were assisted by any legal input on behalf of AmCham?
Yes, you may. Yes, we have a legislative committee that is made up primarily of legal professionals, some independent, and most are attached to companies. and they would have commented on it, our board, and of course we would have sent it out to the general membership. We also have a security committee, which is made up of security professionals in the telecommunications field, retired police officers, and some security personnel in security firms, as well as security personnel attached to companies inter alia the energy sector.
Thank you very much.
But we did not have legal counsel specifically working with us on this bill, I'm assuming that your question was in reference to previous submissions to this JSC similar to the MAT. We did not have that kind of support.
If I could explain, some of the rationale for my question resounded in the questions which came from AmCham and some of the general comments. For instance, asking whether the offences are extraditable. The answer is yes, provided that they meet the conditions of extraditing under the mutual assistance in legal matters legislation, which is a separate part. So somebody who's familiar with that area of law would have known that, but I saw it appear as a comment. Sure. So I wondered if it was a mix of commentary, which you've now confirmed, that it's not exclusively from one end of the equation, but it's a general commentary, and I take it that way, yes?
Correct.
Okay, thank you. May I ask you, you've identified several clauses, beginning with clause 4, passing through and ending with clause 37 of the bill. Are there any particular items in relation to these that you wanted to put onto the public record? Please bear in mind that our listening population or viewing population will not have the benefit until the report is published of the precise submissions that you have made to the committee. So perhaps it is wise to take the opportunity to just give them a glimpse into some of the concerns that AmCham has flagged for this committee's attention.
Sure. Mr. Chair, let me start by placing on record my gratitude and the organization's gratitude to the committee for receiving the submission and for inviting us here and for the work that Ms. Bruce did in putting it together for us. The first one just is in relation to the definition, clause 4 of electronic mail message. We were wondering why an electronic mail message was defined only as an unsolicited data message, including electronic mail and instant message, as opposed to simply a data message including...
Thank you. We can perhaps tell you that the key was really in the lack of solicitation and the fact that any email message may technically be unsolicited, because someone may decide to email someone today. Obviously, it doesn't call first to say, look, may I email you? Do I have permission to email you? And therefore, you can say that any email could be unsolicited. So we focused this definition coming out of the HIPCA model legislation, which we've considered, to treat with really the issuance of spam messaging in the context of the legislation where you can have harm caused by an overburdened system of this particular type. So it was in the technical context that we had gone that way. What we will be doing in our clause-by-clause analysis as we matrix out your suggestions and observations along with other stakeholders' observations is that the committee will, for the benefit of the record when it is made public, give its position in relation to each of the items and submissions as we discuss them. But that is the answer to your question, but I propose not to interrupt you until you have made your full submission, unless you wish us to consider something specifically.
Thank you, Mr. Chairman. Would you like me to go through them one by one, or just the ones?
As you please, the ones that you consider that are of important moment.
Okay.
As we have the benefit of the media sitting with us and keen persons in the national communities that are paying attention.
Okay. So I'll skip clause 5 because I think it's really self-explanatory. But going on to clause 6, we weren't sure whether this was in reference to what, as a layperson, I would refer to as a backdoor to access a system, as opposed to remaining logged into a system. I don't know if the legal meaning is the same, but they suggest two different but related acts. So as you're well aware, as all the committee members are well aware, you can access a network or a single machine and leave a file in there that would allow you to continue to access either periodically or constantly once it has access to the internet, which is different to remaining logged into the system, say on a big network, as the case may be, or a single machine. So we suggest the widest use of the available terminology in terms of creating the offense. And then with regard to Clause 7, it speaks to the first point I raised in the opening, which is that the fines for criminal activity or cyber criminal activity should be, in our opinion, sufficient to deter. And in some cases, there are varying ranges of fines here. I think the lowest being in the bill $100,000 TT, which, I mean, given the nature or the transnational nature of cybercrime in general, is very low. And therefore, we are suggesting an increase. We have 300 here, but in some cases, it's 500. Given how often or infrequently legislation is adopted, is amended once passed, maybe we should go toward the higher end rather than the lower end for penalties under the Cybercrime Act. And then 7D and E speak to moving or copying data to any computer storage device. And we're saying that it should explicitly mention that moving or copying data to a device or medium outside the network is also prohibited once the access was improperly gained. Right? The meat of the submission, or part of it, again, is in Clause 8, which I know you discussed extensively with the Media Association. We share the views expressed previously that there should be a public interest exception. So that public interest exception, just for clarity, is not for the media. It is for anyone. I mean, everyone is familiar with the Volkswagen case, for which there's still payouts, where data was falsified to beat emissions standards, and the damage to the environment and the impropriety that would have gone into actively seeking to beat that, we don't subscribe to at AmCham Trinidad and Tobago. And so it is any form of information that may be gathered that has a genuine public interest implication. We do not feel that we do not believe that the people involved in bringing this to light should be subject to prosecution. We leave it to the legislators to figure that out. I know you had lengthy debates on that, but
whilst you're on that clause,
Sure.
would you give us your view in that public interest exception as to any qualifications to it? How does AmCham view the treatment of hackers in that scenario?
And that's where the public interest exception would come in. I mean, nobody encourages hacking for hacking's sake. One would have to, I'm certainly not an expert either legally or in terms of the subject area, but being a former journalist myself, and although I don't wear that cap anymore, former secretary of the Media Association, I am very aware of the conceptual issues, and sometimes public and private officials who are engaged in acts in which they should not be engaged seek to hide that. And if someone were to access the information in a manner that would then allow the public to have access to the information and remedy a situation where the public's interest was subverted, then it is reasonable to assert that those people are doing a good and therefore should not be penalized for doing a public good. Yes?
I broke my own rule of not interrupting, so I'm reverting back to the lack of interruption. Please, we'll hold our questions towards the end.
Okay. Thank you again, Mr. Chair. Clause 12. We're not sure if it's a typo. I mean, if you don't mind, you can clarify. If you prefer to wait, that's fine as well. It's clause 12. It's under C. It's not in C. It's a paragraph under C, fourth line in the bill, in the version I have, where it says that may I read it for the and intentionally and without lawful excuse or justification grants access or gives the computer data to another person, whether or not he knows that the other person is authorized to receive. The language there is confusing, and we're not sure if it should be unauthorized. Because if they're authorized, we don't understand where the offense would arise.
It's properly stated. It's meant to be authorized. It's to catch the circumstance where the person passes on information to somebody who would otherwise have lawful authority to have that information. So you can't come and exculpate yourself by saying, I hacked the information and I hacked it in circumstances where I in fact had authorization. You fell within the scenario of continuing to be logged on or breaching the parameters of your authority to be there. And then you handed that information to someone else. Turns out that that person is someone who was lawfully capable of receiving that information or being in possession of that information. It's to catch the loophole argument which would arise where somebody says, no, I'm not guilty because that fellow was authorized to receive that information. So it's to catch the mask of an innocent infringement or an infringement which is more than it should have been.
Would you indulge us and give an example?
Sure.
Of such?
So this particular clause it addresses, as the marginal note says, unauthorized granting of access to computer data. So a person who, through authorized or unauthorized means, obtains or accesses computer data which falls into any of these categories now, trade secret, national security, is stored in a protected environment. A person who does that, whether authorized or unauthorized, and intentionally and without lawful excuse or justification, grants access to or gives the computer data to another person, whether or not he knows that the other person is authorized to receive or have access to computer data, commits an offense. So it's to catch the scenario where a person deals with certain types of subject matter and gives it to someone, and that someone may in fact be someone who is authorized to deal with it. That authorized person entering the equation is not capable of curing the mischief, which was the fact that someone broke the law. So it didn't matter that the person gave it to someone who was authorized. It's to remain with the person, the hacker, the person who intentionally did something, and it's to make sure that that person is debarred from having a defense where he says, well, the person that I gave it to was in fact a person who was authorized to receive it anyway.
Thank you, Chair. Forgive me though, because in 12.1, it says a person who through authorized or unauthorized means. So if both parties were authorized, I understand it in the context of one party being unauthorized. But if both parties were authorized, it doesn't speak to what they do with the information. I'm still, forgive me, I can be very slow at these things.
Not at all. The position is taken out of precedented literature. Multiple versions of law exist elsewhere with the same provision. This is intended to treat with unauthorized granting of access to computer data. So it takes care of the scenario where you have both someone who is authorized to treat with information and someone who was unauthorized to treat with information as it relates to matters of serious consequence, national security, trade secrets, matters which can be commercially exploited or matters which can affect national security. So it deals with that class of person. It then goes a step further to say if that person intentionally gives that information to either an unauthorized person or someone else, whether that person is authorized or not, that the act of giving that information can be criminalized.
Thank you. Moving on then to clause 16. This has to do with the collection or use of images of a sensitive nature of an individual, particularly here limited to the private area, meaning genitals, pubic area, buttocks, or breast, and then either shares it, publishes, etc. We are suggesting that this may be narrow, because, for example, we've had cases where somebody could attempt to body shame someone. I don't know if you think that will be captured later on in the clause that is meant for cyberbullying, but in as much as you have a specific clause with regard to images, you may wish to consider widening it. And Ms. Bruce was reminding me, and/or either the use of the actual image in the commission of a crime or the promotion of a product, etc. So infringement on their personal brand, personal image, but also then the manipulation of such image and use for any number of things, including but not limited to the promotion of products or what have you. Yes? Okay. Clause 18, we're suggesting a little bit of clarification as in further specificity to make clear that this clause refers to cyberbullying and what the definition of cyberbullying. Well, I think you addressed clause 20 with regard to extradition earlier. Pardon? You want to do it? Go ahead.
In relation to clause 21 in particular, this considered the practical applications of the law and the process to be used. In particular, you're looking at the fact that from our consultations, it may be necessary for warrants to be signed late at night or early in the morning or even on a weekend, and where, as per the proposed clause, the warrant should be issued under the hand of a magistrate, it may be difficult in the case of expediency to have access to one. So in some cases, justices of the peace sign certain warrants. Would warrants for this act also fall within their purview in lieu of a magistrate? That is our question to the committee.
You're questioning or you're recommending the use of the justice of the peace into this?
It's a question as to whether or not that is contemplated.
So specifically, it's a magistrate that must issue the warrant and no one else. So the use in practical senses, which you may have been referring to, falls under a different piece of law. In fact, that's the Summary Courts Act, where justices of the peace may act as judicial officers in certain circumstances. So usually where you see that, that's in relation to bail or other matters which the Summary Courts Act treats with. The preliminary inquiries legislation as well has similar provisions. So that's where you tend to find that blur between a JP and a magistrate acting. But for the issuance of a warrant in this particular case, it is squarely and only the magistrate that can issue the warrant.
Thank you.
So we're at clause 23.
Yes, Chair. In light of the clarification around the magistrate, we would assume that the magistrate would ensure the proper safeguards are in place before acting on this, and we can withdraw our comment on on clause 23. On clause 24, is the law prescriptive on what the magistrate requires, or would the magistrate have be able to invoke or request additional information? Our concern really is what appears to be, from a layman, this is simply a layman's point of view, a low threshold to ask the magistrate to act.
Sure. I note your submission, just to assist you a bit, the one that is in writing. And you were looking at the concept of production orders. And the comment made was that these are usually completed by a judge. If I could assist you, production orders, where you are asking the High Court to intervene, falls in the civil realm and in the criminal realm. The civil realm deals with something called Anton Pillar orders. And Anton Pillar orders are search orders and seize orders at times. And that's usually done in a high court context. And it's not an uncommon feature in a number of things in civil litigation. It's that technique where you can actually preserve information where there's a risk that it may be destroyed if somebody's alerted to the fact that it's being sought. So if someone gets a tip-off, you have the ability to have a search and seize order, which is what an Anton Pillar order is. The magistracy is another domain which can treat with these types of orders. If you look to the Copyright Act in particular, you will note that there is strong provision for the magistracy to be involved in copyright protection. It's something which is a very common feature. Again, the judicial officer acting here is a magistrate. The language is basically set out such that the magistrate must be satisfied on the basis of information. Those form careful safeguards because it means that the officer would have to depose the information to the magistrate. That information is taken to the magistrate must act judicially and issue an order. Once that order is issued, if it turns out that there was an abuse of process or false information, the remedy would be to bring an action against the police for that particular purpose. Again, of course, it's a balancing act, but the point is there is a remedy in the event that something goes wrong, and that remedy is something which is very commonly practiced in our courts. So having a magistrate as opposed to a judge treat with a production order is something which is known to our laws. In particular, the Copyright Act is a very good example of that. And I take your submission to mean whether the committee wishes to have a more established judicial officer treat with the matter as opposed to just a magistrate. And by that, you'd probably be looking at a judge in the High Court setting. Is that the sort of caution you're asking us to think about?
Yes, even though we withdrew the comment with regards to Clause 23, in these clauses, the remainder of the clauses, we are concerned about the potential to limit freedom of expression, and the need, therefore, to ensure that attempts to remedy speech or content that is nefarious in nature are not so designed to so as to interfere with legitimate free speech, which sometimes can be controversial.
Understood.
So that's the consideration we're asking the committee to look at.
Thank you.
Yeah. And with regards to Clause 28, we're looking at 2B in particular, where to get a, I think it's a warrant, to get a warrant to use a tool to be added to or to be implanted or added onto a computer system. Clause 2B says that the officer requesting the warrant must describe the targeted computer system. I'm not sure if that presumes that they would have seen it and realized they can't take the data off without the tool in advance, or if sometimes you may wish to have this tool available in advance of seeing all of the equipment, and therefore whether 2B might be a bit onerous in that you may not be able to describe in detail. I don't know to what extent there's specificity required in 2B. And in Clause 35, Mr. Chair, again, our concern, or what we're asking the committee to consider, is the potential for abuse of freedom of speech and or the fear that might be created and therefore self-censorship that may take place as a result of the language herein with regard to internet service providers or hosting providers, as it's referred to here, having to take information, content, images down preemptively, which this clause seems to suggest a proactive, preemptive removal of information. And so in Clause B, for example, where you say 35(1)B, where you say upon obtaining knowledge or awareness by ways other than a lawful order from any appropriate authority about specific illegal information stored. I mean, in some cases it would be clear that something is illegal, but I think it places an extreme burden on a layperson to determine what is illegal and legal, and therefore has the potential, as it's currently worded, to give power to restrict freedom of expression and to restrict legitimate content which may be online. So we ask that you take a look at that.
Just for the record on this point, because it's a bit of a repeating theme in terms of potential responses, this is the exculpation for the hoster. So a hosting provider shall not be liable for the storage of information in contravention of this act if A, he does it when he does something when he receives a lawful order. In other words, when a court tells him to do something.
Yes.
B, upon obtaining knowledge or awareness. In other ways, he informs. I just want to point out to you that it would be the prosecution's burden to prove that he had knowledge or had awareness of the circumstances. So it isn't a very easy trigger to cause the removal of this defense in his protection. But I do hear the submission made. I just wanted to just point that out to you. Okay? So you're on to clause 37?
Yes. Same, it's more or less the same consideration. Mr.
Understood. We've noted the general comments which AmCham has provided and the rationale which was very helpful in considering these submissions. We thank you very much for putting that into context. May I invite members of the committee to participate in any questions or clarifications or issues that they may wish AmCham to consider? I see your submissions were so clear that the members have few questions. I think Member Ramkisoon may perhaps jump in at this point.
Thank you, Mr. Chair. I was looking for the comment specifically which dealt with the concern about the international treaties, and I saw that you made reference to a Council of Europe Convention on Cybercrime, and I believe in your submission you were sharing with us that you had made inquiries with the TTPS that we are not signed on to some of these agreements, and I was just interested to know what was the concern, if any, on why this was highlighted at this point in terms of when we're looking at the cybercrime legislation.
That's on page 8 of your submission, under general comments.
Mr. Chairman, through you, of course, we had considered the Council of Europe Convention on Cybercrime and other international bodies and their legislation in this area. Because of the nature of cybercrime, it is transnational, and of course, one need not be in Trinidad and Tobago to commit a cybercrime, and likely the victim need not be in Trinidad and Tobago either. So what we did was we had to do research externally to see what obtained there in order to inform our submission. That is why we considered the Council of Europe, noting, of course, that the source pieces of legislation included UK as well. So we looked to see what was being done in that region.
Thank you. May I ask a question? Has AmCham factored in reliance upon things European? Because we've had reference to the Budapest Convention by the MAT, and we've also had reference now to the Council of Europe's position. Has AmCham had a view of the other elements of support which those jurisdictions also use? For instance, the fact that there are mandatory and voluntary codes of conduct for the media, that there are other very serious laws which articulate along with cybercrime laws? Because I'm quite intrigued to understand AmCham's view, because Trinidad and Tobago only has the benefit of the common law, as it may be viewed in a cyber perspective, and also the Computer Misuse Act. So it's not correct to say that we don't have cybercrime laws, because we can, in fact, treat with offenses which happen in the cyber environment with use of the common law and sometimes some statutory measures. But what has AmCham's reflections upon the manner in which freedom of expression, in particular from that fourth estate the media has been managed, looks like. So when AmCham makes a recommendation that there is persuasion in the Council of Europe structure, is AmCham also recommending that there be an imposition of voluntary or mandatory standards upon the media, etc.?
Mr. Chair, I think the best way to answer your question is extremely directly, and that is that we are not recommending that there be any mandatory standards be imposed on the media. My understanding is that the media houses, which are part of the Media Complaints Council, which I think needs revitalization, do have internal standards and have procedures for reviewing, upholding those standards where issues may arise. Personally, and because we have not discussed this at AmCham, I don't think I can truthfully report it as an AmCham position. But personally, given my varied experience in public life, I think that any code for the media, given the historical and changing role of the media, must be voluntary and is the limits of which are prescribed by the boundaries of the truth in libel and defamation laws.
I'm going to ask Member Dillon to jump in. I just wanted to ask you, we've spoken to the broad categorization of media houses. I think we can all find great restraint and management by media houses because they've been subjected to the discipline of self-regulation in the face of damages, in the face of defamation suits, etc. What's your view on the citizen journalist, the person who says, I'm a journalist because I've put out a blog or I'm reporting on something? Because there's one aspect of the law that is well managed because of responsibility, in particular in media houses. What's AmCham's view on the other end of the spectrum?
Mr. Chair, we believe that we believe and hope, I should say, that in the marketplace of ideas will result in good enough information. And I have to say good enough because it's never perfect. Getting to the citizenry to make the best decisions. We do not believe that journalism is a profession which should be licensed in any way, which seems to be, I'm inferring from your question about citizen journalists whether there should be any restrictions and boundaries. But we do believe that journalists or people aspiring to be journalists, and I also make the distinction between a journalist and a reporter. So one just passes information along and the other seeks to verify it and add context and so on, should be limited by the truth. And the truth is the defense of a journalist.
Thank you. Just for the record, the committee certainly, and I speak for myself here, we don't propose any form of regulatory management of journalism. I'm asking the question because when we lift from the European context in particular, in that jurisdiction, when they make a recommendation that this is the law, there are other standards that co-regulate these things, including voluntary and prescriptive standards in many different jurisdictions. So I just wanted to point out that sometimes when we consider that X country has a great law, the question is, where does that law sit in the middle of the other laws that work with them? And that was just the exploration that we were looking for. Member Dillon.
Thank you, Chair. In fact, the question had to do with the definition of a journalist from AmCham's standpoint. But the second part of that question would have been in relation to your Clause 8 submission. Specific exemptions should be made for disclosures of whistleblowers and journalists when their actions are in the public interest. how do you define that public interest, and who should define the public interest in AmCham's view?
So, Mr. Chair, through you, I think the debate on Tuesday last was quite helpful in this regard. Thankfully, I had the benefit of...
But if you read some of the reportage of the debate,
I looked at...
You may not have gotten what the debate was actually about.
No. I looked at it so that I got it verbatim. That is thanks to the Parliament channel's YouTube channel and the unmediated nature of that, so that I did not have to rely on an interpretation or part thereof. But the two principles put forward by Matt, I thought were useful, that you act in a responsible manner. If I understood them correctly, you act in a responsible manner and that there be a public interest consideration. I think those are two very useful criteria. And of course, we have the courts to interpret as the case may be. I think we have some degree of definition in the Freedom of Information Act. And therefore, the broad parameters of the public interests are outlined, given, as you acknowledged previously, the changing nature of public interest with technology and time. I don't know if I answered your question.
You answered it as well as a certain other person that sits in the Parliament with us from time to time, who you may or may not know well.
I think I did a better job.
Yes. Member Padarat, please.
Thank you, Mr. Chair. Mr. Chair, 2 points. Comment 3 and comment 4 under general comments submitted by AmCham. And comment 3 speaks about authorities need to have the power to compel money transfer services, and maybe with your assistance, Chairman, and also with some clarity from AmCham. On this particular point, it seeks to direct us to local authorities with specific remit with respect to money transfer services and the information they would provide in terms of cybercrimes and so on. The question really lies is that are we satisfied, or is AmCham satisfied, that there are other areas in the law, FIU, recently FATCA, AG keeps speaking about proceeds of crime legislation to come, is comforted in terms of specifically dealing with this particular issue. Similarly, when we speak about the extradition, we know through the mutual assistance that there are other ambits of the law that prescribes to deal with that. Is AmCham satisfied that with FIU, FATCA, etc., that the current legislation that exists prescribes to deal with some of these matters and that there is more to come? Or would you like to specifically see these clauses mentioned in this particular bill? That's one. And also comment 4, the burden of proof in terms of the legislation. I found that the comment was a very interesting one, because it said the burden of proof in legislation seems to lightly square on the person who was charged with the offense. And I think the AG sought to address that by saying that the burden of proof in terms of prosecution will be at really the doorsteps of the prosecutor. So I'm asking whether you are satisfied with that explanation provided by the AG in terms of burden of proof 1, and then coming back to comment 3 as well.
I'd have to jump in just to qualify, lest sometimes people run away with something that you see in part, not you, Member Padarat, but as it's edited. The concept of a burden of proof is a shifting one, which moves from prosecution to defense, depending upon how you migrate through the charges as laid and how defenses are made. They vary between proof beyond reasonable doubt to standard being on a balance of probabilities. If a defendant has to discharge a burden, it's usually on a balance of probabilities, and the prosecution's burden is on proof beyond reasonable doubt. So just to clarify that that's a rather complicated area, and it depends upon which charge is laid, etc. But Member Padarat raised a very important point on comment 3, and we're referring to page 5 of your submissions, right? On comment 3, if I could just add on to his question, your comment for the public is, authorities need to have the power to compel money transfer services to give information on transactions that may be under investigation and which may be an important component of establishing proof of or commission of a crime within the bill. So this was as it relates to cybercrime in the context that we've described, or did it extend to the suspicious transactions, suspicious activity reportings in the FIU realm, or the financial obligations realm, or the CFATIF realm? Was it in that wider context?
Chair, may I have a minute to confirm? Yes. Thank you, Chair. To answer Member Padarat's second question first, I think it speaks to our comments on I think it was section 30, in the 20s and 30s, 35 and 37. I mean, as lay people, we do not know for sure, but we are concerned, and we think that this is an issue that the committee and then the Parliament should discuss with regard to where the burden of proof lies, and therefore whether there is the potential to negative, in particular in the context of freedom of speech. I don't know if I'm answering your question, but we're not clear on the issue. We understand the AG's explanation, but it's only when a matter gets to court will you know whether the threshold was particularly high for the prosecution or not. With regard to the money transfer services, I mean, even money transfer services may be too narrow with cryptocurrency and the like, but it was both for proceeds of crime as a result of crimes committed in the act, and then while we acknowledge fully that there is other legislation, we don't think that it would hurt to have some reference to this, whether it be in the SHAPO or otherwise, in this particular piece of legislation. I know this is not the place to discuss the strength of other legislation, but I would say that we are of the belief that white-collar crime needs to be punished, and more needs to be done to punish white-collar crime. And AG, as you know, we have a conversation scheduled in the near future to discuss matters surrounding this, and we look forward to discussing in greater detail when we meet.
Thank you. I could tell you that separately, that there's a very, very, very large and pointed discussion coming at you very shortly, in a matter of weeks. Some instantly and some in a matter of weeks, specifically on white-collar crime. But that's for another forum. Member Padarat, you had another follow-up?
Yes, Chairman. Chairman, with respect to comment 3 again, and a follow-up with respect to the comments provided by AmCham, I don't want to preempt. I know we are doing TTPS next, but it really is an issue that TTPS brought up. But in the context of comment 3, I would like to throw it out there with respect to AmCham. In terms of the limitations of the bill, under money transfer services, it does not specifically detail the issues of phishing and so on, which is now becoming a really big issue. Could you tell us whether AmCham considered the limitations with respect to when you came up with the point of money transfer services, whether or not you looked at other ambits of the money transfer services and some of the limitations that you believe have not been addressed in the bill, specifically with respect to phishing?
Well, if I understood, for example, clause 4, and again, forgive me, Member Padarat, I'm not a lawyer, and this is not my area of expertise in any great detail, but I'm glad you raised the issue of phishing because it's very pervasive, and I'm glad the TTPS is here because we had an attempted incident of phishing to the tunes of tens of thousands of US dollars, and we wrote to the TTPS, and it took us months to get an acknowledgement, and that matter is not yet resolved. And so passing the bill is one thing, having the ability to implement is another. And we look forward to working with the police as we have in the past through our HSC conference and the like, to make sure that we do our part to ensure that we can identify and prosecute people who do commit cybercrimes. But if I understood your question, I mean, would phishing be captured if you received an unsolicited, under the definition of electronic mail message?
Chairman, I think because of this phishing issue has become one that is constantly evolving, from the information that I have and the research I have done, the reason why I raised this particular issue is that it is relatively a realm that is constantly evolving on this issue. So that's why I really wanted to have your perspective on it in terms of the definition. Some say yes and some say no. So that's why I really threw it out, because there are several areas, TTPS and several others, that have raised other offenses that one does not see as necessarily captured in these definitions. So while I may say yes, you may totally disagree with me because of the evolution of this particular issue. I don't know if, AG, if you have some experience in terms of case law that you could provide some assistance on this phishing issue that you can direct us on.
There's a whole host of law and information available on phishing, which is an interesting subset, which can be picked up in a number of different ways. But suffice it to say that lest we incur the wrath of the entire TTPS that's sitting behind AmCham for us keeping them as high as late as we are right now, I defer that for our committee meetings. I was also nudged that the Secretariat also wishes to be considered in the lineup of wrath expression, and you know that the Secretariat is not an easy one. So, Member Rambarat, I know that you want to jump in.
Yeah, I just wanted to very quickly to say that I looked at the submissions. Of course, I think I agree with you on some of what you have said in 5, 6, and 7. On previous occasion clauses 5, 6, and 7, and on previous occasions in the committee, I raised some similar concerns, particularly with having gotten through the system. What happens when you get on a device, which could be more dangerous. So I understand that. Clause 16, I also agree with you that consideration of images, we need to consider it further. Is more than body parts. It could be what appears to be very innocent but very damaging depending on the context. Clause 20, you point to what is a major challenge, and that is the cross-border issues, domains being registered out of the jurisdictions, ISPs, and individuals. Those are some of the things we have to be concerned about. I note at clause 23 where you make observations about freedom of expression. And I just want to say that, in my view, it is not so much striking the balance between freedom of expression and privacy interests, but it is really striking the balance between individual rights and the rights to protection of the law. And in doing that, we expect that we have to interfere with personal fundamental rights, individual fundamental rights. And I myself flagged the money transfer services comment that you made, and it appears very innocent, but the implications of dealing with money transfer services in criminal conduct go beyond this particular piece of legislation. I'm not sure eventually what treatment we would give to it in this legislation, but I know the AG has other pieces of legislation that would deal with money transfer services in the context of criminal conduct. But I think it's a very good observation that you've made. Thank you very much.
Thank you. Member Huggins.
Thank you, Mr. Chair. To Mr. Tuari. Thank you for your very thorough submission here today. Comment 1 in general comments. I see you identified some of the terms used as having a need to be updated to reflect more globally accepted meanings or uses. That was quite interesting. Just wanted to know if there were any specific terms and if you have any recommendations in this regard. And secondly, if you can just expand on how the vagueness of some of these terms may lead to misuse or abuse by the police service and government, in AmCham's opinion.
I'll defer to Ms. Bruce, Mr. Chair.
Through you, Mr. Chairman, in particular, we were looking at, of course, the use of the term logged into, whereas the globally accepted term for that would be remaining or staying when you use malware or other bugs to remain in a system. So it was in particular logged into. We had also flagged in terms of the definitions of, as we addressed earlier, in terms of electronic mail message, the parameters of such, and even in terms of some of the clauses where you look at the intrusion into a computer system, which only specified device or hardware, whereas it did not include the reference to computer data and or other software issues. So we looked particularly at logged in as opposed to saying remaining or the industry standard, what is typically used, and some of the other definitions therein.
Thank you very much. May I ask if you have any questions further of the committee? And if you don't, there is certainly the opportunity to write into us. Our door is wide open as a committee to receive any further submissions that may have arisen in the course of this exchange today. On behalf of all of our committee members, may I say thank you sincerely to AmCham and its membership for very helpful commentary on this bill. And also thank you for attending before us to help us with your explanation as to some of the items and certainly to facilitate a discourse between the two ends of the table here. Is there anything further that you wish to add?
Yes, Chair. Thank you. So just to Member Padrat's point, we do believe that the definition should be wide, given that this bill seeks to deal with criminality in a rapidly evolving space, so that as far as we can, definition should be wide if any deficiencies that we have not already identified are discovered by the committee as you go forward. And the second one is to you, Chair. We do hope that the raft of legislation about which you speak wouldn't come at us and knock us over, but rather would come forward in such a way that we are able to benefit from its movement forward and maybe even contribute to building the vehicle that is best for purpose as we go forward.
Absolutely. Some of it has been launched quite some time now. The commentary on the beneficial ownership for companies has been completed. Yes. The commentary on the aspects of registration of deeds, etc., has been completed. The last package to physically go out now will be the follow the money civil asset forfeiture, which is completed. And that is something that we know AmCham is very intrigued to participate in.
And supportive of in principle.
As we are very intrigued to have your commentary and views. So thank you sincerely on behalf of us all. To our members of the public, we're just doing a quick suspension, not adjournment, to just play a little musical chairs to invite the TTPS team forward to the front table. So we'll be just suspended for a short while and back in a couple of minutes. Thank you so much.
Thank you, Chair, and thank you to the Secretary.
Good afternoon, ladies and gentlemen. As we resume the Joint Select Committee's work into the Cybercrime Bill 2017, we're very pleased to have with us a very high-powered delegation coming from the Trinidad and Tobago Police Service. We, the members of the committee, are still in situ. I will ask the members of the committee for formality to introduce themselves, beginning with Member Rambarat.
Clarence Rambarat, member.
Good afternoon, Paul Richards, member.
Good afternoon, Shamfa Kudjo, member.
Good afternoon, Edmund Dillon, member.
Faris Al-Rawi, member and chairman.
Good afternoon, Ronald Huggins, member.
Good afternoon, Barry Padrat, member.
Member Gopi Schoon.
I should add that Member Ramkisoon, Melissa Ramkisoon, is with us, and she'll be back in a short while. May I invite DCP Harold Phillip to introduce his team, please?
Good afternoon. Let me thank the committee for giving us the invitation to be here. I am Harold Phillip, Acting Deputy Police Commissioner, Crime and Support. On my right, I would ask the members to introduce themselves, and then they'll go to the left.
Good afternoon, Cohen Francis, Acting Assistant Superintendent of Police, Attorney at Law, Organized Crime and Intelligence Unit.
Erwin Akshaw, responsible for anti-crime operations of the Police Service. Thank you.
Amos Sylvester, Inspector Cybercrime. Dale Joseph, Sergeant of Police, TTPS Cybercrime Unit.
Very good to have you. And for members of the listening public, the delegation here from the TTPS is one that has been involved in treating with cybercrime issues for a very long time. I can tell you that there's been a significant amount of work and involvement with the members of the TTPS in the cybercrime unit. Also, too, many of these members coincide with work which is done in the Financial Intelligence Bureau, in general prosecutions, and very interestingly in the Organized Crime Intelligence Unit, as we now have. So this brings a team of a very unique perspective in terms of the application of law, the investigation of matters, and the prosecution of matters. Mr. Phillip, we have received with gratitude a very well-written submission on behalf of the TTPS. I wish to congratulate you on the care and attention which went into this submission. We have been working with Mr. Sylvester as successive governments for quite a few years on the cybercrime legislation. Both predecessors in office and this office has been working with the TTPS. And we're very pleased to have you with us because you can bring forward the testimony to the amount of work that goes into this kind of product. The members of the committee have read, but the population is not aware of your general submissions. And so in those circumstances, may we invite you to indicate if you have a further opening remark in respect of your submissions, to do so, and then secondly, to proceed immediately to identify the areas of focus in your submissions that you would like the committee to give attention to, but whilst you have the microphone and camera, to also ask the population to pay attention to. Over to you.
Yes. I would like to go straight into the submissions. Having reviewed our submissions, we would want to identify on page 1, with respect to page 1 of our submission, that with respect to the definition of the word harm, we saw in the definition under section 18 that harm was only expressed in terms of emotion, and we would really want it to include physical, financial, psychological, intellectual, and social distress. When we look in terms of the bill, we would have seen the word damage used under two provisions. And I'm now on page 2, sorry, page 2 of our submissions. And we would like to see a definition also included, and we did supply some the definition in terms of under the word damage included under provision 4 that speaks the definition. When we look on page 3, I turn to page 3, under clause 5, the term access, when we, under clause 5, we also have a concern and we would like the term access to be defined. What we observe is that under the present Computer Misuse Act, there's in fact a definition for access, and this in fact is under section 3, subsection 4 of the Computer Misuse Act. There's a provision for access, and we would want that provision to be included in the bill. While when we look at page 5 of our submissions, under section 7 and section under 5 and 6, we did include in our submission the fact that we would want these offenses under the Cybercrime Act to be arrestable, to be considered arrestable offenses, whether summary or indictable. And in particular, given the fact that cybercrime is a very well-known phenomenon internationally and it is a very serious crime, we would want to ensure that when we look at the penalties and so on, we also are of the view that whether summary or indictably, that the penalty should in fact reflect an arrestable offense, which is 5 years or more. We would have seen that some indictable provisions there are not arrestable because we have 2 years, 3 years as the penalty. One of the concerns, these are some additional concerns that that we may not have identified in our submissions, but in further reviewing of the bill, we have the view that with respect to, we didn't see a limitation period for the summary offenses. And when we, under the Computer Misuse Act, the limitation period for most of the offenses was summary, only the one for protected computer was indictable, and the limitation period was 12 months. And given the fact that we would have to get evidence from outside sources, we think that the limitation period for the act in terms of summary, for the summary offenses should in fact be 12 months, although if we wanted to push it, we would have also considered 18 months.
So that's the exception to Section 33 of the Summary Courts Act?
Yes, sir.
Thanks.
Mm-hmm. Also, when we look at the Computer Misuse Act under Section 15, we saw that, we observed that there was a provision there which empowers the Commissioner of Police to, in fact, provide authority in writing for a person to assist the police in conducting investigations under the Computer Misuse Act. We also feel that given the skill sets required to pursue investigation into the cybercrime provisions, we also think that that provision should also be included, whereby we may need to have resources from external, so we feel that provision should be made for the Commissioner to authorize persons. Having, and this is, we know that this is just a bill, and we would want to talk about when the bill becomes law. We are hoping that having recently proclaimed the Anti-Gang Act, which is Act number 1 of 2018, when we look at the schedule of offenses under, we would want to include cybercrime offenses under the Anti-Gang Act to be included. We also looked at the Electronic Monitoring Act, and we would also like to include under the provisions of the Electronic Monitoring Act offenses that are under the Cybercrime Act to be considered either for sentencing or for bail purposes. The Electronic Monitoring Act. Anything I left out? These are the key submissions that I would want to recommend.
Thank you very much. Whilst I have such a seasoned team before us, it would be remiss of me not to allow you to give Trinidad and Tobago some perspective, especially as we have Mr. Sylvester here and Mr. Francis here, to talk to what the Cybercrime Unit and the OCIUN have on the table in terms of statistics. Can you give Trinidad and Tobago a little perspective, a little look-see into the number of matters that the Cybercrime Unit treats with, whether there have been prosecutions under the Computer Misuse Act, if the criminal ends of copyright infringement are things which occupy your attention, a little bit of a tour to demystify for Trinidad and Tobago the fact that cybercrime is something that in fact can be treated with under the existing law in certain senses, but only goes so far. It would be a good opportunity to give the country a little understanding into that.
Okay, thanks. The Trinidad and Tobago Police Service, within its remit, there are several pieces of legislation which include the Computer Misuse Act and the Electronic Transfer of Crime Act, Transfer of Funds Act, Chapter 79, number 51. We have, in fact, over the years, been having quite a number of reports made with respect to, when we look at the Electronic Transfer of Funds Act, we would have had offenses ranging from fraudulent use of credit cards, trafficking in counterfeit cards, possession of card-making equipment. We would have had obtaining goods by false pretenses, using either false expired or revoked cards, and actually theft or taking or retaining possession of cards. In 2017, I have data as of 2017. In terms of the number of reports of card fraud, there would have been close to 1,694 reports, and the dollar value for those reports would have been totaling about just around $14.5 million. We would have undertaken several prosecutions with respect to fraudulent use of cards, trafficking in counterfeit cards, as well as possession of card-making equipment. In these prosecutions, sometimes one person would be, in fact, be prosecuted for more than one offense, and the data would have indicated that in we would have had a total of about 78 prosecutions in 2017.
Is there a dollar value to that 78 prosecution pack?
No, I could provide that for you. In terms of, in 2018, initially there were quite a substantial number of reports that focus upon persons either responding to emails whereby they would have indicated that they needed to supply some identification information with respect to banks. And in fact, their accounts were hacked, as well as we had the issue whereby persons were in fact putting in empty envelopes into the fast deposits, and were in fact getting sums of money credited to the account, and monies were in fact withdrawn by these persons. These matters were most of them were recently reported. Yes, we have commenced investigation, and we have been successful in a few prosecutions so far. However, we continue also to get reports of fraudulent use of credit cards, some of the earlier mentioned reports, and to date we would have had about 747 such reports.
Can I ask you if there are what the numbers look like for charges, prosecutions, or convictions under the Computer Misuse Act?
Under the Computer Misuse Act, we would have seen, my recollection, there were about 18 prosecutions under the Computer Misuse Act. Oh, no. Let me 81.
81.
81.
Thank you. May I ask a related question, albeit that some of it has now been partially decriminalized, and this may catch you unawares, obviously. In terms of criminal libel or criminal defamation, in the way it stood and in the way that it halfway exists right now, do you know those numbers by chance, if anybody has been prosecuted under those laws?
No, I am unable to say at this time.
Thank you very much. Sorry, I interrupted you. Are there further statistics that you may have with you today that you wish to disclose?
No, not at this time.
Okay, thank you very much, Mr. Phillip. May I ask if there are any other of your team members that wanted to address us specifically on certain items? I know you have legal, I know you have technical, I know you have other skill sets at the table with you.
No, but we are willing to respond to any questions.
Thank you you're anticipating me well, Mr. Phillip. Thank you so much. May I just ask a few questions for my own part and then ask members to join in, of course? in the recommendation that we treat with child issues, child pornography, online predators, etc., is it that the TTPS felt that we should, in addition to what is criminalized under the Children's Act, that we should provide for it here in the cybercrime legislation?
Upon reflection, we felt that the provisions under the Children's Act were pretty adequate.
Because it's well treated under the Children's Act,
yes.
and even goes a little bit further into how we treat with luring and other aspects as we improved it in the package of laws that we have in the children's laws. In the period 2015 to 2018, we've amended a significant number of laws, including the Children's Act, to deepen the prosecution possibilities for children. And I'd ask you to know that in Parliament right now, on the order paper, we're treating with the concept of broadening those criminal provisions. So thanks for that clarification. May I have just another one asked? In treating with soliciting, inciting, encouraging, recruiting persons to join terrorist organizations or commit acts of terrorism, is it that the TTPS felt that this should be an improvement over what is in the anti-terrorism laws, as the TTPS may be aware is about to be amended to treat with these matters?
Similarly, after discussion, we also felt that the Anti-Terrorism Act would cater sufficiently.
Thank you very
these
much.
Provisions.
There was another submission here, very interesting submission, about causing harm by communications and looking to the definition of harm in Section 18. And then there was a very useful reference to the case of Michelle Carter, who was charged for manslaughter of her boyfriend after sending him messages which encouraged him to commit suicide. In looking at the recommendations that we better define harm, did the reflections go anywhere close to the New Zealand experience where harm is treated in a similar fashion to this, or was it in a different context that the recommendation to better define harm was made?
We looked at the United States definition, and in so doing, we wanted to better define it because we felt that it only identified emotional harm.
So in Section 18, I see. So where Section 18.4 says harm means serious emotional distress, the TTPS was considering the more tactile versions of harm, physically getting to the person, financially as well. Would you have looked at emotional distress as including financial distress? So where we had the recommendation that we go to physical injury, death, public interest, etc., are some of these capable of falling under emotional distress, or you wanted to see them listed out? So the TTPS is looking at broadening the aspect of harm to include, and I'm using just the phrase, the tactile versions of it as well, the physical getting to you versions, akin to assault and battery sort of versions, yes?
Yes.
Okay.
Yes.
And just a few more questions from me. In terms of the burden of proof, there's a very important observation that the TTPS has made throughout the bill, that some of the clauses propose satisfaction of elements of the offense which are too high. That's some of the points here, that the prosecution would have a difficult case in stepping into prosecution. And then there was a specific recommendation made that the committee should consider reversing the burden of proof in certain circumstances. Could I invite you to expand that a little bit more? Last time I interviewed a stakeholder on a previous day, I was accused of speaking in legalese, but it's very rare that we get the opportunity to have your legal officers appear before us, and so the committee, and in particular I as the chair of the committee, take the opportunity to ask the hard legal questions. So could you assist us, or perhaps one of your team members, with this burden of proof, and in particular the recommendation for the reversal of burden of proof as it appears?
I would call upon
Mr. Francis.
Mr. Francis.
Thank you.
Chair, there would be some instances where we may have an investigation being conducted that is of a cybercrime nature. We may have a suspect in custody, and the evidence that we have or that is in our possession is not enough to take us to that threshold where we would be able to ultimately demonstrate by way of the evidence what the real intention was of the suspect in committing this particular cybercrime offense. We are suggesting in such circumstances that a reverse burden be placed on the individual, since they would be better poised to explain the circumstances under which they committed the act. But that would be in those circumstances where during the course of that investigation, we don't have that evidence that would take us to that threshold to demonstrate the intentionality of the individual.
And for the benefit of the listening public, I just repeat what I did with AmCham. The reversal of a burden of proof is an acknowledged feature of our Constitution, where no adverse inference as to constitutionality is to be viewed under Section 5 of the Constitution because there's a reversal of burden. The standard of proof for the person upon whom the burden has been placed in reversal of burden scenarios is a balance of probabilities. And once that has been made, then the burden shifts to the prosecution. So I just wanted to get that onto the record because it's a very interesting submission. Could I ask you through Mr. Philip, Mr. Francis, could I ask you to assist us with your views on the public interest argument exception? I don't know if you're aware, but the Media Association of Trinidad and Tobago came forward and gave the committee a very, very helpful submission. In fact, it's the first time in 5 years from the records that I inherited that we've had that kind of submission come from the Media Association, and we thank them for it. But their submission includes a caveat that says nothing in this act is intended to criminalize matters which are done for the public interest. That's essentially what it says. It gives an exculpation of liability that if something is reasonable and done in the public interest, that there should not be a criminal charge. I just wondered, insofar as that's now in the public domain, what the view of the Trinidad and Tobago Police Service is on that exception to criminality in that circumstance. It's much broader than just for the media. It includes the general public interest argument in facilitating disclosures which could otherwise be criminalized by persons who obtain them surreptitiously.
2 points, Chair. In the first instance, the issue of public interest and that fine balancing act that is being suggested by the media fraternity is one, in my respectful view, and I guess the TTPS as well, that should be dealt with in the hands of the court. From the TTPS perspective, we are charged with the responsibility of investigating reports where there are suspected breaches of the law. And in that regard, where those matters may come before the TTPS, obviously we will investigate those matters, and where there's sufficient evidence based on the law, put those matters respectfully before the court. But to better aid the committee, through you, Chair, if we may be given an opportunity to read what has been put forward by the media fraternity and respond in writing to better advise the chair on our position on this matter.
Sure, I'll consult with the Secretariat, and thank you very much. My last question before the floor opens, but perhaps I should leave it for Member Padarat because he asked the question in relation to fishing, and it forms part of their submissions. So may I open the floor for members of the committee to participate please? Member Ramkisoon.
Thank you, Mr. Chair. I do have a few questions, unfortunately. My first comment comes from what the chairman had just said in terms of harm. And I just want to know if the TTPS is willing to consider, instead of listing out all the measures of harm, instead of considering to cause harm or threaten or force unlawful acts to another person, if that would be summarize all that you would have listed to the committee, if they would like to consider that instead. Because that came from another group, and I thought it was a good submission. Do I need to repeat it for you? Okay. So 18.1 would be a person who uses a computer system to communicate with the intention to cause harm. And I know the issue is harm is not in capturing bodily harm. So it says to cause harm or threaten or force unlawful acts to another person commits an offense, if that would be acceptable for you at this point.
Again, Chair, we would like an opportunity to consider the recommendation that has been made and respond in writing.
Okay. Thank you for the response. My next question is on page 2 of your submission, which is based on the definition of a computer that includes computerized devices such as cell phones and ATMs, and it will be useful to include a list of devices which are classified as computers along with the definition of each. And my position, just my position, not the members of the committee, just my position, I'm reluctant in listing the devices because if you look at the bill, there's at least 3 definitions that can allow you that provision, because we have computer data storage medium, a computer program, a computer system, a device. And I did listen to the comments made by Mr. Phillip, and a lot of the scenarios or cases that came in 2018 was to deal with empty envelopes at ATMs where monies were deposited and then withdrawn later. But is that really a class as a cyber crime in your view at this point?
May I caution the TTPS not to answer that question just yet, because it's the subject of active investigation and matters, and I don't want them to be held.
Maybe let me rephrase it.
Yeah, I don't want them to be held to a point of view that maybe find itself in court.
Okay, let me rephrase it. Okay, my concern is with the submission to include ATM machines and other devices. Maybe in the future we don't know what devices might be the next opportunity for those with criminal minds. But the thing is, I'm reluctant to take the suggestion to list the devices, and that is my standpoint, and I would like to know if you are willing to urge me to reconsider, how would you do so?
Perhaps I could assist her as well again. The definition of computer system in the Act was something which we had spent a lot of time discussing at the pre-LRC stage and LRC. And it reads, computer system means a device or group of interconnected or related devices which follows a program or external instruction to perform automatic processing of information or electronic data. And we drew that from several examples so that that would specifically include anything that is linked, in particular handheld devices, etc., etc. So there's a broad definition, but one can always go prescriptively, which is a scheduled list of matters, or broad and prescriptive, and then let it follow what we call the ejusdem generis rule, meaning it'll be interpreted in the manner in which the matters which came previously suggest. So we take the point of view that there are 2 different views. One is prescriptive by the TTPS, and one is for general application as the bill suggests.
I'm right, and I thank you, Mr. Chen. I'm of the view that we should keep it broad, and I don't know if the TTPS would like to share why they chose a more prescriptive view. I don't know if it's based on the cases that you have dealt with, so that's why I want to give you the opportunity to state why you went prescriptive instead of broad.
I would ask Inspector Sylvester.
And I'm sure it was so that there was certainty in the laying of charges. Perhaps.
Member Chair, if I may give a little guidance on it. Sometimes when we are pressed with certain investigation and taking matters into the court, while as technocrats we understand fully what is a computer, sometimes the issue arises more in the judicial arena, where persons seem to have some confusion in their minds as to what is a computer. So we may be dealing with one case today, and you would find that the ATM is considered a computer, and next 3 months, similar matter comes up in a different court or during a different investigation, and a judicial officer may held that it is not a computer. But what we have also noted is that in Jamaica and Grenada, they have actually, the minister responsible actually has the autonomy to make provisions in the schedule where he may list what is or is not a computer. So it's actually joining with the other countries in harmonization of the legislation to say that this is so that to assist judicial minds when they have to deal with their administrative functions.
And I like that reasoning, because I would not have thought of the reasoning by different courts give you different, I don't want to say judgments, but an overview of what is defined as a computer, which I would think is covered squarely by the bill before us. So,
Member soon it even goes into a darker realm. Sometimes the judicial mind says that an element of a computer which is capable of standing on its own if it's plugged in elsewhere is not a computer, because at the point in time that the court looked at it, it wasn't working, whereas it may have been working at a point previously. So I understood the TTPS's submission to be such that it was absolutely clear to the judiciary what something would be in an attempt to ensure that there was certainty in the elements of the crime.
So I guess in other words, they are suggesting to introduce a schedule into this bill, which we don't have. I guess that is what you all are asking. And I'm glad that that was able to come out from this clause, because that wasn't in the submission. So that's good. My next question is in relation to the refusal to render assistance for investigations, which is dealt with in Section 22. And you made a comment that, for example, a person may intentionally refuse to give a password to access the evidence being sought. Now, in the bill before us, there is a person who fails to comply with this section. Are you all with me? Okay. A person who fails to comply with this section commits an offense and is liable to, on summary conviction, to a sum of $100,000 or imprisonment for a year. Now, I'm getting from the submission that you want a different provision for passwords or persons who are not willing to communicate with the TTPS to give them information. Is that what this submission is about?
To better crystallize the submission, what the TTPS is seeking to have included in the bill, because we do encounter it from experience, under 22(1)A, in addition to providing information, we would like to have the words included password or key inserted within 21(1)A, because someone may have their device locked by way of a swipe pattern. That may not be construed as a password. Likewise, you may come across some encrypted data that requires a specific key to put it into an intelligible format that can be used. So we would just like to include those two words to better make it clear to an individual, so that when we go to the court and we obtain our warrant, our order, that we put in specifically in that order that they're required to produce the password or the key, so that when we read and show that warrant to them, there's no doubt in their mind what we are asking for, given the provision under 22.2 that deals with failing to give that assistance.
Would that also include, just to interject, Mr. Chair, through you, would that also include that password or key biometric fingerprint, which is quite common in terms of data release in the present scenario? And how would that work in terms of the law and the person being forced to put their fingerprint to release that encryption?
You're correct, member, because there are devices that are locked by way of biometrics, and that is something that should be duly considered as well.
Including eyes, iris patterns. Are we going to go that far then?
Which is why we have a 3/5 majority in this bill.
Now I want to move away from that.
We get constitutional now.
This bill does infringe the Constitution, which is why it's done in a 3/5 majority purpose. Just before Member Ramkissoon asks her one question, when you get a chance, if you may, could you let us know whether the TTPS, without going into specifics of any matter, has treated with or is treating with allegations of death or physical harm which may or may not have been caused in a cyberbullying environment?
At this point in time, I am unable to say, but I would need to make further checks and respond to the request.
I'd be grateful, and if I could add to that list in your further submission, if you would let us know the number of allegations of domestic violence that occur in this cyber environment, specifically insofar as the Domestic Violence Act permits harassment in any form, and that may very well be in a cyber form. Okay? I know you may not have that with you now.
Yes. But we certainly get some of that through the use of social media and so on.
You do get some of that?
Yes.
You see, Mr. Philip, if I could explain what I'm on about. We have, as a committee, been discussing this law during the life of this Parliament, but I, as a member of the previous Parliament, also spent a further 2 years in that Parliament discussing this law. And Trinidad and Tobago does not have the benefit of somebody exposing the quote-unquote mischief. What is cybercrime? What's the harm? What's the economic impact? So in having a discussion about rights, Member Richards on the last occasion was very careful in discussing with the MAT and with other stakeholders to ask where does one draw the line between an individual's right and a collective right, both of which are equally important. So if we could ask you to assist us with some of your statistics and information to open this up so that the committee would be better able to share the data which demonstrates why we as a country should or should not be considering certain things. So it's on the back of that. So whilst you're considering that information, if there's anything else that you are aware of, but which we may not have specifically asked for, please feel free to add it into that so that we can open up this issue to the country, not only in Budapest they do it this way, and in Europe they do it this way, and in Canada they do it this way, but who are we? Who is Trinidad and Tobago? What do our numbers look like? So you see, you gave us a submission a little while ago which was immensely important. $14 million of transaction in cybercrime environment, and hundreds of matters and thousands of matters. That begins to tell a tale of our country and the risks that we are facing. So we'd very much appreciate the TTPS's assistance. And if we could ask you to lean a little bit further to one of your brother departments, which is the fraud squad, because there may be fraud in a cyber environment that you may be treating with. Okay? Thank you, sir. I interrupted Member Ramkissoon.
Thank you, Mr. Chair. I want to go back to the response given by Mr. Francis, a few minutes ago, in relation to Clause 22, was Section 22. You have brought into the light that you would want more information to be given, or password or key or fingerprints or whatever, to help with the warrant. My question is, after the introduction statements, we learned that the TTPS may need provisions to hire a special skill set to deal with filtering and deciphering and decrypting information. And I don't know if this would even be necessary now to include in a warrant if this skill set is provided for in the TTPS to give you such information without the need of having I don't want to say suspects, but the person's computer needing them to have to give you that key, because now you would have software or specialists now to assist you with that.
Member, let me attempt to answer the question. I think Mr. Phillip made mention of Section 15 of the Computer Misuse Act, where the commissioner had the whole power to put somebody as an authorized person in writing to facilitate the involvement in any routine police investigation of a cyber nature. Now, cyber and computer generally, no man's an island, and we recognize that in some field there may be some areas of quantum physics. The police service may not have anybody dealing with that area of science. And it's in that breath that we may seek to have somebody to work alongside us to assist us in getting that type of information and presenting it at the end of the day towards a court, whether it be GPS analysis or forensic quantum analysis, or any type of very far-fetched means. Now, in the US, quite recently, within the last 2 years, we had actually have places like the FBI going to Apple just to try to get their technology, access to the backdoor to their technology, so that they could actually investigate routine crimes where terrorism was used or persons who shoot mass shooters, right? This clearly indicates that no law enforcement agency universally, there are persons who may have that ability, and sometimes you actually need to go to find somebody who would be able to do that, come however they may. And it was only in this light Mr. Phillip recommendation stood fast.
Thank you, Mr. Sylvester. Now, saying all of that, based on your experience in the cybercrime unit, have you had this scenario where you would have to go to specialists or Apple or Samsung to help you with any of your cases on unlocking software or computers or decipher or anything like that?
We would usually rely on our international stakeholders, other law enforcement agencies abroad, to see whether they would have had any success doing similar. And if they did, we would try to rely on their expertise in this area.
My question is really to see if these words, other than information, is really needed in this bill to really give the TTPS the assistance that they may require. And at this point, I'm not seeing it, but I guess when we have our committee meeting, we can further discuss it. And if you want to further submit on this clause, I openly welcome it, Mr. Francis, who's smiling, so I'm okay. But my last question, because I know the other committee members would have questions as well, is Section 25, where the submission before us, the police officer, you are asking that the rank of the superintendent be changed to a first division officer. And that is to kind of open up a wider pool of persons. And that section deals with preservation of evidence, I believe, or criminal investigations. I, again, am very reluctant to this suggestion because I would always want a police officer who's trained and skilled and have the experience to make that decision as opposed to any officer.
So, member, if I may, it's this submission comes from the backbone of submissions which the TTPS has made in anti-gang, in anti-terrorism, in money laundering, in proceeds of crime, and in fact, we've discussed this in Parliament on a number of occasions. Okay. The TTPS functions on a junior-senior relationship basis. So the junior officer is supervised by a senior officer. But in this case here, we're dealing with ex parte orders from a judicial officer, the magistracy.
Right.
And the backbone of this submission, and correct me if I'm wrong, comes about on the availability of personnel, not the seniority being better or not, because if you don't have people available, then the matters are stymied. And it's something which we came across in particular at the anti-gang level when we actually had to treat with the evidence coming out of the anti-gang cases which collapsed during the state of emergency under the last government. So it was born on the back of experience at the TTPS as to the practical issues for the implementation of the law. Lest you have a law, you have a car, but you don't find the key for the ignition. So you got a beautiful machine and the key can't turn because you just don't have the right key. And the rank and file supervision, the DPP's oversight in criminal prosecutions, that's the modern trend of thinking coming in this scenario.
And I thank you for that response. And based on the statistics that was given, 78 prosecutions, that doesn't really show a big backlog to say that we shouldn't have a superintendent.
No, the 78 prosecutions comes on the back of the 1,400 reports. And then that is 1,400 in 1 year, which then adds on to thousands the years before. So in fact, you're proving the case in the reverse. It is in fact that very reason why you want to have evidence available by having the correct officer available to act at the first point in time. So it's the other way around. Okay. Feel free to jump in, Mr. Philip and Mr. Francis.
I like the seniority.
You have explained it properly. So certainly in a very practical way, we would want to ensure, based on the availability of our first division officers, we have made this recommendation. So we have a greater pool.
Just 3 quick questions through you, Mr. Chair. And this may sound like a really basic question, but on your page 1, causing harm by communication, section 18, the definition of harm should be expanded from serious emotional distress to include causing physical, financial, psychological, intellectual, and social distress. What is intellectual distress in your opinion?
I was tempted to say something in Parliament at times, but I won't.
I've never heard that term intellectual distress before. I have quite some training in psychology, so.
And Paul, I didn't mean that in reference to anybody here.
I know. We are public.
Well, I gather that having looked at a particular definition, one would want to feel that it may, while we know that there would be some kind of financial loss in some instances, in terms of intellectual property, there may also, in other ways, persons may be doing some thesis, some sort of, some writing, some document.
It means intellectual property.
Yes,
intellectual
property.
distress.
Yes,
right, I understand that. In terms of social distress, and this is a really left wing, because this is harm caused through a computer. And if we include social distress, there have been some suggestions in other jurisdictions that would this have implications for advertising, unsolicited advertisements on phones through computers, which in some people's estimations, for example, a minor getting an ad for alcohol or a person getting an ad for a sale and they're not satisfied could very well say they're emotionally distressed. Have we thought through the implications for this in that regard? Because these are, if we're going to include these phrases and words, we have to understand all the implications as they may come when you include a wide berth of very specific definitions in these kinds of scenarios, especially when it comes to the transfers of data and information from one device to another, from one person to another, in some cases, in many cases, in unsolicited manners.
We have provided the widest definition, and we have made some suggestions, and it's up to the committee to determine which ones.
Could I ask if there was any model precedent that you were attracted to that drove some of these submissions? I can tell you that the committees, the the government's draft of harm was something which originated out of the laws in New Zealand. So that's the precedent that we used in terms of considering the recommendations for Parliament. But was there something in particular that caught your eye, perhaps in the Commonwealth or elsewhere, as to the treatment of harm in this fashion, broadening it to include some of the elements you've suggested?
Well, certainly we did have a look at the Canadian, the British, although the British is the cybercrime bill, and we also had a look at the Australian model as well as some of the other Caribbean models.
Thank you so much.
All right, continuing to page 2. The bottom of the page, provide clear guidelines for law enforcement as it relates to identification, seizure, and preservation of digital evidence. One of the groups that came before us earlier, and I think your esteemed panel of professionals will do well to peruse the submission of the Trinidad and Tobago Computer Society. One of the issues that they brought up was a very relevant issue inclusive of seizure of equipment which may be shared. For example, a service provider is providing services to several different companies, storage of data, transfer of data, and one of these companies is the subject of investigations. But if there's seizure of the equipment, it will affect several other businesses, and they may be liable, and that seizure of that equipment may cause their businesses to fail. But one of the clients of the overall provider may be the one who is the subject of investigation. How does the police see that playing into that seizure of equipment and preservation of digital evidence, and also in the specter of off-site, off-location, or off-island cloud storage?
Inspector Sylvester would comment.
Member, in answering your question, in terms of the cloud, one, we will have to engage the host provider in order to get the data, taking into consideration what mutual legal assistance treaty is available to us. That is the only way we could have access to that, because it's physically, not technically here. Right? The first one, business. One of the first things we always try to do is always allow for business continuity, right? Now, the only thing is, when you look at how information is obtained, usually all law enforcement usually have to work with, at the beginning of the day, is an IP address. The IP address would point to a location. The IP address will not indicate how many businesses there are at that location. All it will do is point to an address. Law enforcement then goes to the court and requests a warrant to go to that address to see what is there. In doing so, if law enforcement reach and realize that the area has several businesses tied into that one, law enforcement will take every opportunity to try to ensure that business continuity goes on as much as practicable. But it would also depend on what is found in terms of if arms and ammunition, let's say, are found in a server. We simply just can't allow business continuity to go on as if nothing happened. There will be some breaks in business continuity. And in the same way as if pornography, child pornography, or anything of that was found, we simply cannot allow that to continue at that point. So each case will be done on its own merit, but one of the first principles we actually have is to allow business continuity to exist as much as practicable.
Thank you. Arms and ammunition is quite different to child pornography, though, being found in a server. So the other issue is clause 20 on page 5, jurisdiction of the Cybercrime Bill 2017, and it states in your submission, clause 20, it is important that jurisdiction extends to locations in instances where the accused is a national of Trinidad and Tobago and commits an offense outside the territorial jurisdiction. Is there a precedent for that through you, Mr. Chair?
Yes, extraterritoriality is a common feature. It finds itself, for example, in the anti-terrorism laws and a number of laws, interception of communication, etc. So extraterritoriality is not an issue.
Well, if there's going to be the suggestion, in my logical thinking, I'm hoping anyway, that if if there is access through the law to deal with a national of Trinidad and Tobago, would that extend to non-nationals of Trinidad and Tobago who cause damage here?
Yes.
It also extends to that. Okay, and finally, in terms of my sweep, I think it's the Computer Society of Trinidad and Tobago. And I think Digicel and Flow, Columbus Communication, I should say, both raised the issues of their service provision and access as opposed to them being the servant. And they raised it in the context of the law enforcement trying to get information based on one of their clients and issues related to their confidentiality clauses in terms of their service provision contracts with their clients. And the fact that in some instances, they just provide access to some sites, for example, Facebook, Instagram, through which the alleged crime may be taking place. And what's the police service's perspective on that through these service providers who they provide a broadband service and other services, but they are not the originators of the intellectual property of Facebook or Instagram or any of the other portals through which the alleged incidents may be taking place. And parts of the bill, I should say, may seek to shut down that if they've caused a particular harm, and the shutting down of the access to that site. I may not use the actual Facebook and Instagram, but any other site that may be the conduit through which the alleged act or harm is taking place may affect other people in the process. And what's the service's perspective on those kinds of scenarios, especially as online services and social media evolves to be even more pervasive. And when you look at the footprint in Trinidad and Tobago, it is extremely high. So I think we have to look from a law enforcement perspective on how, because your opening page suggested that the bill should protect against, and you listed quite rightly so, a number of possible offenses in terms of protecting citizens of Trinidad and Tobago. So what is your perspective on those scenarios where more and more we'll be accessing sites and services that may not originate here but may cause harm in several areas?
Member, let me attempt to answer your question.
I apologize.
It's a very long question. Now, I'm aware of the submission made by the ISPs. Now, today an ISP and some of the ISPs in Trinidad use their traditional rules, which is they just simply offer broadband. Nothing prevents them from changing their functions tomorrow, because ISPs generally, apart from broadband, they may wish to diversify, and they may be hosting, they may be a caching facility, and there's nothing that they have to go through to actually implement that. This is just simply a management decision, and they switch, right? So nothing prevents them. So a broadband provider today could be a hoster tomorrow. That's the first point. Sometime last year, the police service attempted to be proactive. We had an issue of malware that was in dealing with our international stakeholders. There was an issue of malware emanating from Trinidad and Tobago. And we attempted, through the normal means, to indicate to the ISPs concerned that the malware was hosted through their services. And we told them directly that it was no offense on their part, but we still needed for it to come down. And we were hoping that we would get the sort of cooperation that was expected, since we were just merely asking. And both ISPs indicated that we had no sort of right to ask for that. And they said it will depend on them actually communicating with the clients concerned. And one or two of them communicated with one or two persons, and the two persons understood what was happening, and they took down whatever was causing all the problems. But there were another two who didn't really understand the whole language, and they left it up. And the police were powerless to do anything. And I'm saying this against the backdrop of a ransomware or some global catastrophe hitting Trinidad and Tobago through the use of the digital infrastructure. That once something happens, the police service would be toothless to say that we cannot get the information from the providers to actually stop or to actually give them any direction to remove the offending malware or offending pieces of whatever information is being hosted. Now, you would have spoken about Facebook, and somebody mentioned in past YouTube, whether something there and we're not asking, and we will never ask the ISPs to take down a host or something that somebody posts on Facebook, or we'll never ask the providers to take down what somebody put on YouTube. But because we recognize that we have multiple points of ISPs in this country. So simply saying, on one side, take it down, the persons or the clients who under the other operators would have access to it. And sometimes person would be able to go around and get a VPN access and go straight to the US. We are only going to ask for persons to take down that which is objectionable from things that are under their purview. So that if a local provider is hosting something, that he's a hosting provider, and he has something hosted on his infrastructure, and it's offensive and illegal in terms of child pornography or whatever it may be, we would ask him to take down that, or for them to deal with that aspect and not anything else.
And if I could just add into that, Member Richards, a court, even though one could allege, well, the law speaks to a wider circumstance, you can't direct somebody to do something which they can't do. So the frustration of the order is always a very real thing. For instance, you can't tell someone, paint the sky pink now. It may be just impossible. So the circumstances may render the order nugatory, or may render the person who's affected by the order on an inter partes basis. That's when it comes back to the court and both parties are in court, to say to the court, well, I'm not the host of this. I don't have control over this. I might be able to block the HTML link, but I don't have control over that source data, and therefore that person is not caught within the web of an order which is an impossible order. So there are certain degrees of assistance that persons who are the subject of orders can gain if they take the correct approach, and the court is the arbiter of that.
Just final question. Well, I have more, but I'll just have one more. In terms of cyberbullying, and a question that arose from Member Padirath and others in past sessions, where this is an evolving paradigm for us in Trinidad and Tobago. We have a particular culture in Trinidad and Tobago. While the chairman has indicated, we signed up for public service. So we're supposed to have thick skins. And we have a particular culture where, in terms of the definitions that you sought earlier on, causing physical, emotional harm, etc., we have a culture that, in some senses, encourages what we describe as peacock, but others describe as abuse. You know, and how are we going to rationalize that? One, in terms of ordinary online or social media or cyber world interactions that can become quite contentious, and memes, and amending people's images, and this is not politicians or political satire at some level that somebody considers offensive.
Fortunately, I have no experience in this area, and I've never been the subject of any of those.
You're so meme-proof. So how are we going to deal? What's the police service's perspective on that? Because this is a bill that's, as the AG and the chairman and others have indicated, has had a long incarnation, and laws are never perfect, but we have to have the considerations of what is happening and what can happen, and the trends we're seeing in society presently, with a bit to protecting people, but also being sensible so that people cannot use the laws in ways they would, in manners for which they were not intended. Because I can very well see people getting very hyperactive, for lack of a better term, and putting more strain on the resources of a police service that's already under quite a lot of stress. If these scenarios are not thought through carefully, what are your perspectives on that? And what kinds of reports have you gotten in that regard? So even without the proclamation or the movement through both houses and the proclamation of a bill, the possible proclamation of a bill like this, a law like this?
Well, given that it is well established as to what could be annoying language or offensive language and so on in terms of the law, one would well imagine, and given the provisions of the Act under subsection 2, under 18 subsection 2, that indicates what the court would take into account. Once reports are made to us, certainly these reports would be investigated, because we know that a lot of it is based on how the victim themselves perceive the harm. And at the end of the day, we would look to determine whether we have sufficient evidence to place the matter before the court. Given all what is, if you want to say, we would have the different kinds of Creole kinds of slangs and so on, but still the law is clear as to what is offensive and annoying language and so on. They are clear.
Just quick addendum to that. This law will now, there's broadcast law, and now this is cyber law. And the two forms of media are now in most cases intertwined. If this bill were law, I would suggest quite a number of media houses would be in trouble, as it were, for what is broadcast presently. Are you seeing issues with a rationalization or reconciliation of some of the new paradigms that may evolve with this cyber law in terms of what now exists, which may be, in some instances, unfortunately, a lower bar for broadcast law? A radio will now become a computer on a digital device, let me put it that way, or television outlet. And those are new scenarios we have to consider, because they're streaming online through computer devices.
I would ask ASP Francis to answer.
Member, from the TTPS's perspective, each of these matters we would have to treat on a case-by-case basis. It would be difficult at this stage for us to indicate in any broad way how we may treat with these situations when they arise. So when these circumstances do arise, we will look at, for example, under the same section 18.2, which gives the sort of a checklist as to the things that the court needs to take into consideration in determining whether harm may have occurred. In a similar vein, when these situations arise, the TTPS would look at the particular circumstances of the case and conduct its investigation accordingly and assess the evidence at the end of the process and get guidance to make a determination what, if any, charges may be preferred in such cases.
Member Huggins.
Thank you very much. Just curious, what type of relationship you all have with social media platforms? Example, let's say Facebook, because cyberbullying many times takes place where you have profiles that are not true profiles of persons, fake profiles. And have you all had experience in terms of engaging, let's say, a platform like Facebook, in terms of getting something down, if it may be cyberbullying or so? And if so, second part is, how does the policies of Facebook and others match up to the laws that we have existing in Trinidad, or with what we're about to propose here? Because Facebook would have, and other social media platforms would have certain policies in terms of what they consider to be cyberbullying, or what they consider to be something not worthy of being posted on their platform. So one, have you any experience or relationship in terms of directly relating with platforms to get things off or to trace things? And secondly, how do those policies of those platforms match up with our existing laws here in Trinidad?
Member, let me try to answer your question for you. One, in terms of dealing with these social media giants, Facebook, Twitter, Instagram, in trying to reach out to them, we have to go through the Mutual Legal Assistance Treaty to get information. To be able to do that, we must first establish an offense here in Trinidad, and then something comes in that is called criminal duplicity. So it must be an offense here.
Dual criminality.
And there must be an offense in the U.S. The absence of legislation here means that we could not have pointed out any offense here to be able to get the assistance there, right? So that's one area. Now, two, in area policies and policies like Facebook and Twitter, I don't think persons actually read the policies of these when we signing up to get the accounts. Because I would tell you now that Facebook policy vaguely is that anybody can create a vanity name. I could be anybody on Facebook that I want to be. And that is simply how their system runs. So most times persons come and make reports and say, well, they see somebody using their name, but it's more a matter of education and information and informing them that this is how the system works and this is how it operates. And it doesn't really clash with the laws which are non-existent on our end at this point. But in terms of the policies, even if we have this legislation, the policies of Facebook still maintains. It will now be that we have legislation which we could approach them for information on who may be using their services to cyberbully someone else. In terms of using the word cyberbullying, there is always a difference in language, the vernacular spoken by the persons down here. Sometimes when someone says, you will sit down in a bed of lily or roses, in the U.S., you might think that those things only grow in the cemetery or the grave, and that might be a threat to somebody there. To somebody here, it may not be. If we use the words, I'll see you after sundown, and we try to explain to the persons in another jurisdiction that somebody is actually threatening me, they don't usually get the expression. So we normally have a little tug trying to explain what is the vernacular being used here as approach there, but their decision is final in the matter in terms of whether they actually give that response in the absence of legislation.
And the short point is that it can take years through that cycle.
No, but there is a reporting system on the different platforms. So if an offense or so is committed or something is reported to you that is offensive, have you ever had any success in terms of reporting to get content removed?
To get content removed, it will have to, one, be against the policies of the foreign side. And that would be no. Most of the things don't really defy their policy. Facebook has most of these social media giants have immediate policies where you could actually go and report as an individual. So that if you see somebody using your name and carrying out yourself as you as an individual could go and say, report this, and you state your reasons why, and they will take it down for you. In that sense, it doesn't require a law enforcement effort on that, and persons are guided along those lines. But the general stuff, the law enforcement don't have that way or right to remove or request that they take down. We only pursue in relation to identify who was the one who would have put it up.
And just for the record, what this law will be able to do is to meet the dual criminality issue, which is an absolute requirement for extradition, but it's a key element for mutual legal assistance as well. So we would be marrying up to a position where we, for the first time, have a law that everyone else in the world seems to have, which is cybercrime. Gentlemen, yes, Member Padarat.
Thank you, Chair. Chair, I want to join with you in congratulating the TTPS. I thought that their submission was easy to follow, and it was simplified in many of the areas that had great concern. The two areas that I would like to turn to, you mentioned one of them was the issue of phishing, but also an area that has been a very controversial one, which is the anti-gang legislation. Now, I can phrase both questions relating to the statistics, the data, and the intelligence of the TTPS in terms of answering this question. Those are the areas that I would like the answers to focus on, the stats, the data, and the intelligence. I'll deal with the issue of the anti-gang legislation first. And I wanted to have a perspective from the TTPS of how do you think bringing the cybercrime under the anti-gang legislation will strengthen, and do you have stats or intelligence that would support this recommendation in terms of bringing the anti-gang legislation, the cybercrime under the anti-gang legislation? And also, with respect to the creation of a special provision to incorporate the offense of phishing should be included in the cybercrime bill. You're asking here for it to be explicit. Now, the AG, as well as other members, have indicated that this can fall really under the definition one way or the other. What prompted, and again, I'm asking in light of data, intelligence, stats, what prompted these two recommendations based on that?
With respect to bringing the proposed legislation under the schedule of the anti-gang legislation, when we look at fraudsters, they operate as gangs. There are persons who may be the persons who, for example, persons who are generating these fraudulent bank cards. There are persons who are employed in a restaurant. You may go with your credit card. That person may swipe your card. Then that data now is handed over to John Doe, who may have the software and the blank cards upon which he can now impregnate that data from your credit card. So if we were to marry the activity of the employee at the restaurant with the conduct of the individual who is putting together the cards by putting your data on these blank cards, you can bring them within the realm of engaging in a gang-related activity. Because under the Anti-Gang Act, two or more persons coming together, whether formally or informally, to engage in a gang-related activity. So by putting the cybercrime offenses under the first schedule of the Anti-Gang Act, we are now saying that where two individuals in a scenario where I outlined earlier on, restaurant employee, person who has the equipment coming together to commit this gang-related activity, accessing the person's data, they can now be charged for being members of a gang. Also, whoever is the person who is leading the activity can be charged as a gang leader, and then the follow-on provisions under the legislation that deals with forfeiture of the equipment, etc.
Have you seen high instances of these?
Specifically what member?
I'm asking with specific reference to the scenario you just provided us with, whether or not there are high instances of reports of this type of activity.
I do not have those statistics with me, but I am aware that the fraud squad does receive a number of reports outlining that sort of conduct, and that's just one basic example.
Remember, this is why I've asked for the TTPS to give us some of their data on this.
That was my next question.
Yeah.
If you could provide the data.
Yes, so we're going to expect a package from the TTPS on the wide spectrum, which is from fraud through cybercrime, cyberbullying, and it could even go so far as the matters which involve domestic violence. We saw a very interesting case of revenge pornography being issued on the subject of legal action, which was the closest this country came to a private right of privacy being used to prevent a form of bullying. So that is the spectrum that will be in the TTPS.
Mr. Chair, I'm not sure if it would be even possible to ask the Cybercrime Unit if they can share the challenges that they do have presently, that they could assist. No, they wouldn't be able to.
I'm sure that they'll share their generic challenges with us.
But in relation to that, we can assist them to give them some true bills.
Sure.
That's what I meant, not all their challenges, just related to the legislation before us specifically.
Sure. Thank you. Members of the TTPS and members of this committee, suffice it to say that your attendance this afternoon has been more than worth the while. I join Member Padarat's submission that your written documentation was very clear, very easy to follow, very precise, very pinpointed, and we thank you sincerely for that. There is a bit of information that we've asked for, which will help us to orient a little bit more. Member Ramkisoon has also very sensibly asked for you to push the door open and tell us what else you need assistance on in terms of an enforcement perspective, some structuring that this legislation can provide in this particular realm. Are there any other views, comments, or submissions that you wish to make, Mr. Phillip, you and your team?
Yes. Thanks, Mr. Chairman. I just missed one of the areas that I needed to make a request for, the aspect of damage to a computer system. We did see under Section 7 where the whole issue of damage dealt specifically with computer data. But I know in terms of the data which could be considered the software within the system, they could also have, in fact, damage to the hardware. And I was just, that was one of the requests that we needed to include intentionally or with all lawful excuse, damage a computer system, whether you use the ransomware, whatever you do. But that is one of the areas.
Thank you, Mr. Phillip. We actually read all of the submission, and we noted that you just today focused on a few areas, but we've taken the submission as a whole, and we will be taking the submission against every clause in a matrix where we add all other stakeholders' concerns as well, so we can consider it as a one-round clause by clause. So may we invite you, please, because we're anxious to complete the work of this committee, may we invite you to deliver your submissions as soon as you can, please, the further information requested. Any other submissions you wish to throw in at us in terms of a second round, because we would like to begin to wrap up the public hearings and sit on the clause by clause. We've now fortunately had a consultant come on board, and the timing is therefore very good for the committee to receive a wholesome reflection on the submissions. May I, on behalf of the entire committee, thank you again, Mr. Phillip, Mr. Francis, Mr. Hackshaw, Mr. Sylvester, and Mr. Joseph, for taking time out of your very, very busy schedules to be here on this important matter. We really commend you as a unit for the hard work that goes on. We're very aware of it, and we thank you for making time for us today in the committee. In all the circumstances then, I now adjourn the public aspect of this hearing, and the members are invited just to stay for a couple of minutes so we can wrap up the matters which are in camera. Thank you very much.